Srimati Kanimozhi.
Thank you, Madam. This bill, actually the first speaker who spoke, Honorable Member Gaurav Gogoi, supported the bill, and we thought the discussion will be above politics. But then some people, I think, we cannot let that go, and the temptation is there too much. So, no, but then we are here just not for politics. We are here for, legislation. So
that means because you studied the book.
Anyway, to talk about the bill now, there are a lot of welcome things in this bill, and as the minister has said, the amendments have been brought in to get more clarity in the bill, and we've seen that this code has been in operation for the past 3 years now. My primary objection to the amendment to Section 31, the amendment makes it clear that the central or state government or local authority to whom statutory dues are owed are also bound by the resolution plan as stakeholders. If such a resolution plan has provided for reduced taxes or even no money at all, the state and central governments are bound by the resolution plan as approved by the adjudicating authority under Section 31 1 of the Act. I would say that this can have a very dangerous impact on the public exchequer. The resolution plan is approved by a COC, Committee of Creditors, comprising of financial institutions. The state and central governments are not represented in this. This actually will be giving power to a private body, the COC of a company, to determine or undermine the interests of the states. This, I think, the minister has to take into consideration. And such an amendment is also on shaky ground. The power to recover dues to the state are provided to various authorities under various special status. For example, the Income Tax Department draws its independent power from the Income Tax Act 1961. GST is levied and recovered by authorities under the provision of the Central Goods and Services Tax Act 2017. These are also there to levy property tax, cess, and other legislations by the government bodies. When these authorities have exercised power under those acts, a committee of private financial lenders are effectively overruling these government bodies. Therefore, we are creating a super body which will actually supersede and overrule the provisions of the other statutes. Now can you imagine a situation where these private financing bodies will be interested, will say that the state is more important, the exchequer is more important, and when will they ever put them before their own private interests? So I suggest that the minister must consider equating agencies of the state as an independent category of creditors, as it was earlier done under the Companies Act of 1956, which give them a place in the Committee of the Creditors. And this will ensure that the state's interests are taken into consideration. The amendments to Section 30 are, I also understand that the ministry is bringing these amendments to overcome interpretation of the National Company Law Appellate Tribunal in the judgment of the SR Steels. However, if the government takes a wholesome view on the subject, we can see that the judgment helps small and medium-scale vendors by not allowing financial creditors to take the whole pie. However, this amendment, operational creditors can be, after this amendment, operational creditors can be given nothing. That is something we have to be very careful about. And because of the practices, bad practices of these corporate companies, these smaller concerns will be affected to a large extent. And also, in the explanation 1, it says that fair and equitable. That can be completely subjective to any interpretation. So that also has to be taken into consideration. And when these smaller entities are affected, it will have economically have a ripple effect. And in many cases, these operational vendors and creditors, they have only a due of 2 lakhs or 3 lakhs. And when they are not paid and settled, the entire business comes to a standstill. And already we have unemployment problems, and this country is going through a crisis which has never been there before. So I think we should not add on to it. And the amendment to section 25A, the voting rights of those who form a class of creditors. I think the minister, when she was explaining about it in her initial explanation about the bill, she even mentioned this. But after this new amendment, for example, if there are 100 people who've invested in a flat, and before this amendment, they had if 51 people who've bought flats have one opinion, like they want the money back, and if 49 of them want flats, then they had 2 votes. You could represent both the views. But now, after this amendment, only 1 vote, the representative gets only 1 vote, and the representative gets only 1 vote. So nearly 49 of them, their opinion and what they want is not taken into consideration. And this is very unfair on a majority of the people, because they are just being defeated by 2 votes. And a lot of people, middle-class people, when they've invested, they want the flat. They do not want the money back, because it's been so many years. And it'll become a big loss to them, and it's a lifetime saving. And I think the minister has clearly explained, because it was a concern for many people, section 12, that the framing of the the time frame. There was a lot of question about whether the court proceedings will be included in that or not. Now that the minister has explained, I think it's a very welcome thing that the stipulated time includes that also, and so that it doesn't become a never-ending process. I also wish to, apart from the bill, I'd like to make one suggestion. The minimum threshold for invoking the resolution process should be increased, because it's just 1 lakh now. And if that is increased, I think it will reduce the workload of the tribunals, and also ensure that smaller companies are not dragged into the NCLT under the threat of insolvency. Because these small companies are the ones particularly affected by this, and they end up facing court proceedings, and they're not able to run their companies, and again, it puts them back into a vicious cycle where they cannot get out of their debts. And the minister also has to bring a mechanism to regulate the fees charged by the regulation professionals. In some cases, when the debt is only around 1 lakh, the fees charged by them is nearly 25 to 50,000 rupees, or sometimes it's more than that. And yes, bigger companies have a panel of lawyers to help them out, but smaller companies, they get nothing out of it. So I think there should be some regulation on the fee structure, and with this, I think the minister should look into the suggestions made by this House to make this bill even a better one, a more clearer one. Thank you.